Hello folks, for those of you who are new to my video blog, my name is Steele and I am a family and immigration lawyer in Toronto, Canada. Today we will be talking about a foreign divorce opinion letter concept. Now, if you're listening to this video blog, it's because you or someone that you know wishes to get married in the province of Ontario, but they were previously divorced outside Canada, and as a result, they have to go through a couple of additional steps. Now, in regular situations, when a person has been divorced in Canada, or when they haven't been married at all before, it's as easy as going to Service Ontario, applying for a marriage license, and getting married within 3 months of the issuance of that marriage license. However, the situation gets a tiny bit more complicated when you have been divorced, or your fiancé, spouse-to-be, was divorced outside of Canada. In that situation, the Ontario government requires you to apply for the authorization to obtain a marriage license. Now, in order for you to get the authorization, one of the documents that you need is a letter from an Ontario lawyer, such as myself, basically saying that your divorce is recognized in Ontario and Canada. Now, those letters can be prepared fairly quickly, in 24 hours or so, depending on the complexity of the situation. Now, usually you will need to submit the following forms: application for the marriage license, the statement of sole responsibility, the original or court-certified copy of your foreign divorce decree, judgment, order, certificate, whatever the name of the actual document is, and the original foreign divorce opinion letter prepared by a lawyer. Now, once you have all of those, you send them to Thunder Bay, to the Registrar General. They review the documents and issue you the authorization, which you then take to Service Ontario and get your marriage license. Now, the most important thing that I would need as a lawyer to draft a positive foreign divorce opinion letter is your statement that you and or your ex-spouse lived for at least 1 year at the time that the divorce was filed in the jurisdiction that granted the divorce. So let's say you lived in Los Angeles at the time that your divorce was being filed. As long as you've lived there for at least a year or more, I will have no issue writing you a positive foreign divorce opinion letter. Now, if you haven't, or if your ex-spouse hasn't lived in that jurisdiction for at least a year, it may not be the end of the story. In some cases, albeit a small portion of them, a minority, a foreign divorce opinion letter can be positive even if you haven't lived in that jurisdiction for a year, as long as we can show and make an argument that you have substantive connection to the issuing jurisdiction. What that means in simple terms is that your functioning as a citizen, as a person, was mostly centralized in the issuing jurisdiction. So let's say if you had a bank account in Los Angeles, you owned a business, you went to school there, you have family there, you're an American citizen, and usually a California resident, potentially you could get a positive foreign divorce opinion letter. Now, this is very fact-specific analysis, so we will have to review the details of your case and see if this is possible. I hope that you've enjoyed this very brief overview of the legal information pertaining to foreign divorce opinion letters. And if you need your help getting one, please get in touch with me. This has been